Hey guys, and welcome back. Today's courtroom case is one of those moments where confidence collides head-on with legal reality. What starts as a routine debt collection hearing quickly transforms into a fascinating courtroom exchange filled with unusual legal arguments, procedural misunderstandings, and a judge determined to keep the focus on the actual facts. As the hearing unfolds, you'll see claims about contracts, jurisdiction, and legal theories tested against established courtroom procedure.
All right, we are on the record. First matter is Amex versus Jason Campbell Everett, case number 243818GC. Is counsel here for the plaintiff?
Yes, Your Honor. Dreek Gertzberg, P80136, appearing on behalf of Plaintiff American Express.
Good morning. And sir, you are Jason Everett?
Yes, sir. I'm here on special appearance. I am
What?
the registered agent for the registered.
I'm sorry, you're not Jason Everett?
Yes, I am Jason Everett on special appearance.
All right. So, Ms. Gertzberg, this is a claim of failure to pay a credit card debt.
That is correct, Your Honor.
And I've read the answer that you filed, Mr. Everett, and you deny that there's a contract and claim that there's a statute of frauds problem on the plaintiff's complaint. Is that right?
That's correct.
Okay. All right. So we're going to allow discovery, which is a process in a civil lawsuit where each side can request documentation from the other side with regard to their claim. I'm going to allow written discovery only. And discovery will be open for 90 days. So that will take us to February 6th of 2025.
Your Honor,
Yes.
as attached to the defendant's answer were a number of what appeared to be discovery requests, a number of written requests for, I guess I would say, similar to interrogatories and requests for productions of documents, but
Okay. Well, then I
they
guess I
were,
would suggest that your client should answer them.
well, they were not presented in the appropriate manner. They are not in conformity with the
Well, counsel, you can
court
either have
rules.
your client answer them or you can file an objection.
Right away, the judge establishes a calm and professional tone, making it clear that both sides will have an equal opportunity to present their positions. Courtrooms operate on evidence, procedure, and applicable law, not on confidence alone. That's why every claim must be supported by facts that fit within the legal framework. As this hearing progresses, pay close attention to how the judge separates emotional arguments from legally relevant ones.
In the case, if there are some substantive issues, then you'll need to brief the issues and bring them before the court with the proper motion. So witnesses need to be exchanged by February 6th of 2025. Exhibits need to be exchanged by February 6th, 2025. And motions may be filed and heard as permitted by the court rules. We will set this matter for a non-jury trial. That'll be a Friday. We'll need some date after March or in March or later.
March 14th,
March 14th
9:30.
at 9:30, and that'll be in person here at the courthouse.
I just can't have my client have to respond
Hang
to
on just a
50
second, counsel.
interrogatories.
Just a second, counsel.
March 14th.
I'm sorry, counsel. Did you have something you wanted to say to the court?
I can't, in good faith, have my client answer 50 interrogatories.
Well, I guess counsel, I think I've tried to direct you as to uh, what your ability to respond to those are. So I'm not going to practice law for you, Ms. Gertzberg. You'll need to do it for yourself. So we will schedule the matter for a non-jury trial in person, March 14th at 9:30. And is there anything else for the plaintiff?
No, Your Honor, thank you.
Okay, anything else for the defense?
Judge, I'm just curious on why this counsel is here when I have another counsel on my paperwork.
Okay, Ms. Gertzberg, can you explain your involvement in this case?
We work at the same firm. The appearance of counsel of one member of a firm is the appearance of all members of the firm.
All right, so I think that that
Fair
is
enough.
pretty common response, and I think that is acceptable. So,
Fair enough, yes.
okay, all right then. That's all for the record today, and we'll send a copy of this pretrial order to both parties. Thank you. American Express versus Jason Everett, case number 243818 GC. Is counsel here for the plaintiff?
Yes, good morning, Your Honor. Andrew Tetro for plaintiff.
Good morning. And sir, you are Jason Everett?
Yes, sir, I'm here on special appearance and I reserve all my rights under UCC 1308.
Okay, good morning.
Good morning.
All right, this is plaintiff's motion for summary disposition. Mr. Tetro, you may proceed.
Thank you, Your Honor. Yeah, this is plaintiff's motion for summary disposition. It's being brought pursuant to MCR 2.116 C9 and C10. C9 is failure to state a valid defense, and C10 is no genuine issue as to any material fact. Excuse me. The evidence that's offered in support of plaintiff's motion establishes that Mr. Everett opened a credit account with plaintiff in November 2016. He used his card to make numerous purchases over the next few years. He accrued a balance which went unpaid. The account went into default, and now the plaintiff brings this count of breach of contract to recover the unpaid balance on the account.
Okay. There was a response filed to the motion by Mr. Everett. Did you receive the response?
I don't believe so.
Mr. Everett, did you file the response with the plaintiff's counsel?
Yes, sir, I have tracking number. I can track it.
I'm sorry, you have what?
I have a tracking number for the mailing. I can track it.
This was filed back on March 24th, is that right?
Yes, it was sent out the same day, USPS.
What's the title of the document?
Notice of judgment to dismiss for lack of contract and jurisdiction.
It's notice of motion to dismiss for lack of contract and jurisdiction.
Okay. Does it also say high priority judicial declaration?
Yes, it does.
Okay, we did receive that.
Okay, would you like to respond to it?
Yeah. So the filing that Mr. Everett has filed, now it's my understanding that this is a response to the motion for summary disposition. It doesn't really address too much of what's in the actual motion for summary disposition. It does talk a lot about the UCC and Fair Debt Collections Practices Act. Most of what the plaintiff talks about, or excuse me, most of what the defendant talks about in his response is not applicable to this case. UCC doesn't apply to consumer debt. The Fair Debt Collections Practice Act doesn't apply to the originators of the debt.
One of the most interesting moments arrives when procedural issues begin taking center stage. Discovery may not sound exciting, but it's one of the most important stages of any civil lawsuit because it allows both parties to exchange information before trial. The judge repeatedly emphasizes fairness over technicalities, especially when one side represents themselves. That balance between following court rules and ensuring everyone receives a fair opportunity is what keeps the legal process functioning.
So one of the things argued by Mr. Everett is that there is no contract, and what is your position with regard to the existence of a contract? You said this is a breach of contract complaint.
Yep, there's a contract. There was a contract attached to the complaint that was filed. There's a contract attached to this motion.
Those were signed by both parties?
I don't believe they were signed by any party, but there's no requirement for a signed writing. Statute of fraud doesn't apply to credit accounts. The terms of the agreement that are attached to both the complaint and the motion are clear, and the terms of which are clear and unambiguous, that use of the account is acceptance of all the terms of the agreement.
Okay. I'm just looking at for the complaint in this manner. It's strictly a breach of contract complaint. Is that right?
Yes.
Okay. It's not an open account claim.
No, I don't believe so. I think it was just one count for breach of contract.
Okay, Mr. Everett, response?
I wholly disagree based on all of my research and based on all of the listings from UCC, listings from the Internal Revenue Code, subsection 166 on charge-off reporting. My Exhibit A was proof that the account was charged off. That basically prevents financial institutions from profiting from a debt that was already satisfied through other means, which means if it was charged off, they got a tax credit for it. I also listed in here that if they cannot enforce if they've already received benefit. That's just one of many here, sir, that are legitimate and are applicable to consumer accounts and consumer law. Statute of frauds, UCC 2201 requires that a contract for the sale of goods for the price of more than $500 be in writing and signed by the party whom enforcement is sought. They have no signatures. They have no electronic signatures. They have no wet signatures. There's quite a bit of things here, sir, that are not aligning with what the plaintiff is claiming.
Well, let me ask you this. I mean, you did have a credit card that was from American Express. Is that right?
Yes, sir.
And looks like you used that credit card for charges at numerous local locations, including Granger Waste Services, Meyer, Capital City Grower Supply, Chipotle, and they haven't been paid for those charges. Is that right?
Well, sir, my use of the without prejudice notarized UCC 1308 in connection with my signature indicates that I reserve my common law right not to be compelled to perform under any contract that I did not enter into knowingly, voluntarily, and intentionally. And I do not accept the liability associated with the compelled benefit of any unrevealed contract or commercial agreement, whether it be adhesion or hidden.
Okay. So you used a credit card and charged it up and didn't pay it off. I mean, that's really what the facts are here in the case. They don't
have any mechanism for enforcement, sir.
As the discussion continues, the courtroom starts revealing the difference between legal theories and practical courtroom strategy. Researching statutes is important, but simply citing legal terms isn't enough unless they directly apply to the dispute before the court. Judges consistently evaluate whether an argument actually addresses the legal issues involved. This moment highlights why understanding the context of a law is just as important as knowing the law itself.
If there is a genuine issue of material fact, I find that the defendant did use his American Express card, did run up charges and receive a material benefit by using it, and that Obviously, he made some payments on the account, which acknowledged that there was an agreement that if he used it, he would pay. And then he stopped paying at a certain point in time and went into default. The court does find that his use of the credit card and acceptance of the benefit of using that credit card to make purchases does constitute a binding agreement, and therefore I do find that plaintiff is entitled to summary disposition of this claim. The various laws that were cited by Mr. Everett are not applicable. And so that's the ruling of the court. I will sign an order. Was there an order, a judgment submitted, Mr. Tetro, with the?
Yes, Your Honor. If you have the motion packet, it should be the very last 2 pages of that whole motion packet. The last 2 pages of the exhibit should be a proposed order, or excuse me, proposed judgment.
It's about a 300-page motion packet, so it's a little bit difficult to.
Should be the very last page.
Okay. Okay. All right. That's all for the record in this matter. I'll sign the order and send it to the parties.
Thank you, Judge.
Welcome. Case number 243844GC. Is counsel here for the plaintiff?
Yes, good morning, Your Honor. Michael Kirschenheiter for the plaintiff, P75722. How are you?
I'm well, thank you. Good morning. And good morning again, Mr. Everett.
Yes, sir.
Okay, this is plaintiff's motion for summary disposition. Mr. Kirschenheiter, would you like to, did you receive the response filed by Mr. Everett in this matter?
I did, Your Honor. It's titled motion to dismiss, same as the previous case, but we did receive it, yes.
Okay. All right. What would you like to tell the court?
Judge, it's pretty straightforward. It's a credit card claim. It's an account stated claim. It's a C9, C10 motion. We don't believe there's a genuine issue of fact. There's been no valid defenses pled. Defendant opened up this credit card. He used the credit card. Statements were sent to the address that he lists as his address. He made payments on the account. There's a balance due and owing. We've provided those statements showing the use of the account as well as an affidavit as the amount due and owing. Pursuant to C9, only the pleadings may be looked at, and defendants did not technically file an answer. He filed an affidavit under the UCC, does not deny any of the allegations in the complaint. There's no affirmative defenses that have been pled. Under C10, we don't believe there's a genuine issue of material fact. We believe we've got the burden with our pleadings. So we would ask that our motion be granted and judgment enter.
Okay, thank you. Mr. Everett, your response?
Yes, sir. Again, no material contract, no informant consent, no signature, no social security number listed. I reserve my rights to be compelled to exercise any compelled benefits that were hidden from me at its initiation. Same as before, sir. I don't believe they have standing for claim.
Okay. All right. Well, the court has reviewed both the motion and the response, and it's very clear based on the exhibits attached to the plaintiff's motion that that Mr. Everett did have a Bank of America card and did utilize it for multiple purchases, many of the same locations that were indicated in the previous case, including Meyer here in the Mason area. See, the consumer's energy bill was paid or was charged to it. And so clearly Mr. Everett received multiple benefits by using the card. He did make some payments under the cardholder agreement, and at a certain point in time defaulted and stopped making payments. I do find that there is no.
Now the pressure begins to build. The plaintiff focuses on documentation and the history of the account, while the defendant continues relying on broader legal concepts to challenge enforcement. This contrast perfectly illustrates how civil litigation usually works. Courts generally look for evidence, records, agreements, and conduct rather than abstract legal philosophies. As both sides continue presenting their positions, the judge carefully narrows the discussion toward the facts that actually matter in deciding whether the claim can move forward.
Deputy, if you would also inform Ms. Bender there's a no contact order with her co-defendant, Mr. Burns.
I will do that, sir.
Thank you. All right, are you Christopher Burns?
I'm the living man, Christopher Burns, not the entity you got on this paper charged with all cap letters.
Are you Christopher Burns?
I'm the living man, Christopher Burns, not the entity you got charged on this paper with all capital letters.
All right, I can't understand what he's saying, Deputy Malone. Can you repeat it?
I am the living man, Christopher Burns, not the entity you got charged with all cap letters on this paper.
Okay. Well, obviously you're living or you wouldn't be there. Just answer the question if you are, and you are Mr. Burns. So, Mr. Burns, you were indicted by the grand jury yesterday on a number of charges. First 4 counts, I'm sorry, just on 2 counts, I'm sorry. The fifth and 6th counts. And count 5 alleges that on or about June the 29th, 2024 in this county, you knowingly sold or offered to sell methamphetamine, a Schedule II controlled substance, in amount over bulk, less than 5 times bulk. And then count 6 alleges that on about the same date, you possess that amount. Now, each of those are third-degree felonies, which, if convicted, carry a possible prison term between 9 and 36 months, and a fine of $10,000, and a possible license suspension of 6 months to 5 years. Now, you're entitled to have an attorney to represent you. If you don't have the money to hire one, the court will appoint one for you. And I see you filled out a financial statement. Is everything on this financial statement correct?
Yeah.
All right. When's the last time you were employed, Mr. Burns?
I don't know. I like to see the official criminal complaint against me, and I like to plead the fifth. I ain't got.
The court will find that you are entitled to appointed counsel. I'll appoint Attorney Dennis Kirk to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf.
I don't want to enter no plea. I like to see the official criminal complaint against me first.
Well, you're going to need to talk to an attorney first. I'm not in a position to do anything today until I hear from everybody involved in the case on both sides. So, in the absence of counsel, the court enters a not guilty plea on your behalf. I'll set a bond.
I don't want it.
Don't interrupt me, Mr. Burns. I'm going to set a bail review hearing by Zoom tomorrow at 8:30. There'll be a final, a first pretrial on your case on October the 17th at 1:00 p.m. There'll be a final pretrial on November the 20th at 1:00 p.m. And then the trial will be set for December the 19th at 8 a.m. Bond will be set in your case for at $5,000 plus your own recognizance, which is your promise to appear. and if you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. You'll be required to pay service fee deposit of $171 prior to release to cover the statutorily required fees. If you make bond, you'll be on a pretrial supervision of probation department, 117 East Main Street. Be required to report to them as soon as you're released. Then once a week for 4 weeks after that, as they determine, undergo random drug testing in my order, provide phone numbers for home, cell, and employer. Recommended by probation, will be evaluated for substance abuse or mental health issues. If there's any treatment indicated, you enroll in and file that during the pendency of this action. You'll be under house arrest at your residence at 236 East Beach Street in Hillsborough, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any case.
One of the strongest moments in this hearing comes when the judge begins asking direct, straightforward questions. These questions cut through lengthy explanations and focus on simple factual issues. That's often where courtroom cases are won or lost. Instead of debating every legal citation individually, judges frequently examine whether the essential facts are disputed. When those facts become clear, many complicated arguments suddenly lose much of their impact. It's a reminder that clear answers often carry more weight than complicated explanations.
Okay, this is case number 24 CR 141, State of Ohio versus Christopher A. Burns. President representing the state is Assistant Prosecuting Attorney Adam King. President representing the defendants, Attorney Dennis Kirk. Are you Christopher A. Burns?
Living man, Christopher A. Burns.
I'm sorry?
The living man, Christopher A. Burns.
I can't understand you.
I'm the living man, Christopher A. Burns, not the corporation you got signed on this paper in all capital letters.
Okay, so you're Christopher A. Burns. All right.
Living man.
Well, obviously you would be dead. If you were dead, you would be here, so that seems to be unnecessary. All right, now, Mr. Burns is indicted in a two-count indictment for aggravated trafficking, possession of methamphetamine, third-degree felonies. The question of Mr. Burns's competency was raised, and so on October the 23rd, the court ordered that defendant be examined by an examiner from the Forensic Evaluation Center. I received a letter dated November 7 from Dr. Aaron Nichting, N-I-C-H-T-I-N-G, indicating that there was an attempt made to evaluate Mr. Burns on November the 7th. On that date, he refused to participate in the evaluation, including after attempts were made to gain his cooperation. So they indicated they could not complete the court-ordered evaluation. Mr. Kirk, have you wish to offer anything regarding the matter?
My understanding is my client's advising that he fears that his right to remain silent would be violated by participating in the evaluation. I've advised him that anything he says in this evaluation would not be used in a jury trial or court trial. And he's advised me he still does not wish to take part in this interview.
All right, well, I guess there's two options here then, Mr. Burns. One is, and Mr. Kirk can discuss this, is that, if there is no evidence that the defendant lacks competency, the court could go ahead and make the findings since he's refusing to participate. Or I could order him to do it again. Mr. King, you have anything to say on the matter?
No, Your Honor, I'm obviously not as familiar with this defendant
Sure.
as Mr.
All
Kirk.
right.
I don't know anything about his competency at this point.
Mr. Kirk?
My conversations have been somewhat like what the court experienced a minute ago with the some unusual concepts and things raised. So I've been unable to really have a clear conversation with my client.
Mr. Burns, you have anything you want to say?
I've asked him to file some things, he hasn't filed it. Asked for the verified criminal complaint in my arraignment, I haven't received it. I haven't received all my evidence. I asked for all the hard copy evidence against me.
I guess
haven't received it.
I should have made it clear. I'm going to interrupt you because you're talking about a lot of things that really aren't relevant at this point. The question before the court isn't about all that other stuff. There's a process for that. The question is whether you have anything to say about the fact that you refused to participate in the evaluation.
Plead the fifth.
I'm sorry?
I might remain silent.
You're advised to remain silent.
I'm advising myself to remain silent.
Oh, okay. Mr. Kirk and the court to be satisfied that you are able to consult with counsel about this matter. And in order to do that, there has to be effective communication, and he's indicating that that's not the case, and he believes, or he's concerned, and the court's concerned, that that may have a bearing upon your ability to participate in the trial. And so, you're going to need to be evaluated. So it's going to be the order of the court that you be taken into custody pursuant to section 2945.371 C2. The defendant has been released on bail and refuses to submit.
As the hearing approaches its conclusion, the overall direction of the case becomes much easier to understand. The court has listened patiently to both sides while consistently returning the discussion to evidence, procedure, and applicable law. Whether someone represents themselves or hires an attorney, the same legal standards ultimately apply. This hearing demonstrates why preparation, relevant evidence, and legally supported arguments remain the foundation of every successful court case, regardless of how confident either party may appear.
I just apologize for my actions and getting too old to be doing this.
Well, that may be the smartest thing you've said in the last 20 years. The question, though, is if you believe it. It's one thing to say it, it's another thing to believe it, it's another thing to act on it. You haven't acted on it. You've been doing this now for your entire adult life, and you don't seem to want to change, and that's the unfortunate part, because you certainly could if you wish to. And I'll say that during the pretrial supervision, you consistently failed to call in or go in and claiming that you were bedfast, which I don't really believe for a minute. I think you were using, and you just didn't want to come in and get tested. I think there's probably a pretty good chance if you go to the jail, you're going to test positive today, aren't you? You're not? Okay, well, we'll find out. Yeah. But in any event, I'm going to follow the recommendation of the state, since you did cooperate. Your testimony was, I think, helpful to the conviction that was obtained, although I wouldn't describe it as extremely cooperative. I think it was the bare minimum, and you were less than cooperative during your testimony, but you did end up testifying as to what happened. So it is the order and judgment of the court that you be and are hereby sentenced to a term of 12 months on count 1 and 12 months on count 3. Those sentences are ordered to be served consecutively to one another for a total of 24 months. And according to this, you were arrested on the 1st of October and released on the 3rd. Is that correct?
Yes.
All right, so you get 2 days of jail time credit. Now, upon completion of this sentence, it is possible that the adult parole authority will put you under what's called post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer on the terms they set, and if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term, which is 12 months for all violations. But if you commit a new felony while under post-release...
This courtroom exchange serves as an excellent example of how judges evaluate claims based on facts, applicable law, and established legal procedure rather than assumptions or unsupported arguments. Throughout the hearing, the court remained focused on fairness, while carefully examining the issues presented by both parties. Cases like this remind us that understanding the legal process is just as important as understanding the law itself.